Hello everyone, welcome to BYJU'S exam prep. I'm Nivedita Raja, your legal reasoning expert, and today we are going to study the part 3 of very important legal current affairs. So how are you all? What's up? What's happening? Tell me something interesting. Good afternoon, good evening to everyone. Good afternoon, good afternoon. So legal current affairs part 3, right? Your CLAT preparation. So we have included them all and we are going to study them today. So the first segment of today is Justice U.U. Lalit is to be appointed as the 49th, 49th Chief Justice of India. Okay, central government has notified the appointment of Justice U.U. Lalit as the 49th Chief Justice of India. He will take over the helm of Supreme Court after CJI N.V. Ramanna retires on August 26th, which is 6 days from today. He was an excellent Chief Justice, I have to say. Now, the article which provides for the appointment of the Chief Justice of India is important, right? Which is the article? It is Article 124, Clause 2. Right, so 124 clause 2 of the Constitution of India provides or confers the powers of appointment to the President. He has been conferred with the power to appoint the Chief Justice of India, CJI. To appoint Shri Justice U.U. Lalit, Judge of Supreme Court, to be the Chief Justice of India with effect from 27th August 2022. This is the declaration. Okay. Now, what is this article? This article provides for the establishment of the Supreme Court. Clause 1 says there shall be a Supreme Court which would consist of a Chief Justice until Parliament by law requires a larger number of not more than 7 other judges. So, the Constitution provides for Chief Justice and 7 judges, but we know that the strength has been increased by the Parliament. It is now 31, right? So, clause 2 of Article 124 says that every judge of the Supreme Court shall be appointed by the President by warrant under his hand and seal after the consultation with such of the judges of the Supreme Court and of the High Courts in the states as the President may deem necessary for the purpose, and shall hold office until he attains the age of 65. Now, this my dear students, is absolutely redundant. That is why I wanted to highlight it. It's redundant. Sorry, I spelled it wrong. Now, Article 124 Clause 2 says, I'm good, thank you so much. It clearly says that the appointment of the Chief Justice of India will have a certain process, right? So, there are judges of Supreme Court, they're sort of like a panel. Okay, so the judges of the Supreme Court and the Chief Justices of the High Court or the judges of the High Court will come together, and there will be a nomination by the appointment by the President. So, in a way, they provide that the leader of the Supreme Court or the head of the Indian judiciary should be appointed in consultation with everyone. So that includes not just the judges of Supreme Court but the judges of High Court as well, right? So in a way, maybe they actually considered that, names should be nominated for eligible people to be Supreme Court judges, and then among themselves maybe they can vote and the President will make an appointment. His vote will be more important, something like that. This might have been the idea, but this idea was never followed, because now the ordinary process of appointing the Chief Justice of Supreme Court of India is, what is it? It's appointing the senior most judge of the Supreme Court as CJI. That's it. The President does not have any say in it. Nobody is consulted. High Court has no role in appointing the Chief Justice of India. So after the Chief Justice retires, the other senior most judge, the one who is who is the eldest among all, will be the Chief Justice of India. So instead of going by what is given in the constitution, they have actually adopted an autonomous process of giving themselves a leader. Okay, now this is something which practically violates what constitution has laid down, but nobody has really challenged it. In fact, NJAC came to implement something which, you know, is written or which is given under clause 2. It was based on a similar idea, but Supreme Court did not allow it, and NJAC was declared void, as it was said that it violated the basic structure of the constitution, since judiciary is being made an independent organ by the Constitution of India. So if you involve executive in the appointment of judges, you are actually violating the basic structure. So based on that reasoning, they completely revoked NJAC, National Judicial Appointment Commission. Yes, the appointment of Chief Justice of India is pretty controversial, practically because they are actually, you know, very blatantly violating what is very clearly given in the constitution. And they are actually the custodians of the constitution. They are the interpreters of constitution. They're responsible for making sure that the constitution is not violated, but ironically, they are themselves violating the constitution for a significantly long time, and there is nobody who can challenge it, because even if anybody challenges it, I am sure they would come up with a certain theory and justify their act. So there is no point, right? So that is why I wanted to highlight it. Now, proviso to Article 124 provided that in the case of a judge other than the Chief Justice of India shall always be consulted, obviously. Judge may by writing under his hand. So basically, appointment in the Supreme Court is dealt by Article 124. Article 124 does not just provide for the appointment of Chief Justice of India, it actually provides for a lot of things, including appointment of every judge of Supreme Court, including Chief Justice of India. Right, so this is what Article 124 says. A judge may by writing under his hand address to the President resign his office. The removal of the judges is also provided for in Article 124. A judge may be removed from his office in the manner provided in clause 4. Now that is not important. One more thing, it is said in layman terms, people usually refer to the removal of the Supreme Court judge or any judge for that matter as impeachment. Mind you, impeachment is only for the president. The word impeachment is used in the constitution only for president. The removal of Supreme Court judges or any judge is very complex and it resembles the process of impeachment, but the constitution doesn't use that word, so the removal of a judge is not called impeachment. Okay, always remember it. Moving on. Conviction solely basis of extrajudicial confession cannot be sustained. Now, before we third party influence, no Stuti, no. So, yes, the name of the case is State of Rajasthan versus Kasturi Ram. Now, there are two kinds of confession. What exactly are they? We'll discuss what confessions are. So, one confession is judicial confession, which is given under section 164 of CRPC. Okay, I might be wrong. Let's delete the article. Oh, sorry, section. I remember it is 164, but I sort of got confused. I think it is 164. The other one is extrajudicial confession. Okay, now what are these? Confession, judicial and extrajudicial. Think about it. Let's say we have A. Okay, he has committed murder and police knows that he has committed murder. He knows that he is not, under a mandate to admit that he has committed murder. So he remains cool. So what? Kind of an attitude. Now he gets arrested and the police comes to its original self and they bash him black and blue. Now in the terror of getting beaten up and in the terror of getting his bones shattered to pieces, he confesses in front of the police that, okay, fine, I admit that I murdered B. Okay, so in that situation, yep. Yes, Sanjana is absolutely right. Third party in that case is COA, Committee of Administration, not Supreme Court. Yes, so let's say that in the fear or because the A is scared of a police officer, he admits to have committed murder of B. Now, he actually has admitted, fine, I am the killer, I am the murderer, do what you can. Now, this confession is made before a police officer. Judicial has a word judiciary in it. Right, so it's very easy. Any confession or the admitting of a fact is called a confession. When you admit to doing something that yes, I did it, that is what we call a confession. Everybody knows it. So if a confession is made to a judicial person or a judicial authority, we call it a judicial confession. If a confession is made to anybody outside the judicial authority, we call it extrajudicial confession. Now, what is the scope of all these? Yes, the scope is pretty interesting. Let's again write it. Judicial, extrajudicial, right? Now, confession made before a judge is relevant, which means that if a person confesses to his crimes in front of a judge, then his confession will be construed as an evidence and the trial will continue accordingly. The man has admitted that he has done something wrong. He has confessed his guilt. The judge will decide the punishment accordingly. That confession will be relevant. It will be very important, and judiciary can convict him solely on this basis that the man has admitted to his guilt in front of a judge. We can convict him. It can be done. But extrajudicial confession is very, very limited. So this case basically relates to the scope of extrajudicial confession. Extrajudicial confession is held to be a weak kind of an evidence which is not deemed as a confession, and conviction cannot be based on it, because if a person admits to his guilt in front of anybody other than judge, the judiciary does not take it into relevance for various reasons. For example, let's say a man just admitted to his guilt or just admitted to doing something because he was scared that if he doesn't say anything, the police will break his bones. He was just so scared, right? Or a man confessed something to a person who, maybe heard it wrong. So it cannot be taken into testimony. It cannot be accepted as a strong piece of confession or a strong piece of evidence for many, many reasons. You cannot be sure. And if a man said that I murdered B in front of his best friend, he admitted that he murdered a certain person in front, is not valid. No, Alfia, they're not valid. So let's say that a man admitted to his guilt in front of his friend, right? Now, according to the Evidence Act, that confession is irrelevant. So if that person reports this to police that this is my best friend and he just told me that he has committed murder, now police based on this filed an FIR and presented that man before the judiciary. Now the question is, or the problem is, that even if he admitted to his guilt in front of his friend, he might deny everything later on, and there is nothing that anybody can do about this, because evidence law clearly states that confession becomes relevant criminal procedure clearly states that confession becomes relevant only when made before a judge. So any confession or admitting of guilt made to anybody else is absolutely irrelevant. And if you are taking it into relevance, so if you're taking it into consideration, you have to make sure that there are other facts supporting it. There has to be corroboration. So if a person has admitted to his guilt, or a person has confessed something to anyone, that confession has to be corroborated, supported by other facts that yes, for example, A said or A confessed before B that he has murdered C. Now this is a confession, but this will not be considered unless and until there are other evidences. For example, the murder weapon was found in A's house. It was testified by various people that the night B was murdered, A went to meet with B. It was testified by various people that A had a certain animosity against B and he hated him. So there are various facts that are pointing towards the guilt of B. Now these facts together with this extrajudicial confession will lead to conviction, but this confession alone will not amount to anything. That is what was held in this case. Okay, but a judicial confession is complete in itself. It is absolutely complete. So section 164 of CRPC says that if a person confesses his guilt before the Supreme Court, before the judge, before a judicial magistrate, a conviction can be based on it. It is not like a person just said that I admit that I murdered B and the judge will convict him. No, there's a lot of process involved. He's actually been cautioned various times by the judge himself that what is it going to entail later on. Like, even if you are admitting to your guilt, it is not that I'll acquit you, you will still be punished. So the word of caution is given to him. He will himself come before the court and ask him or tell him that he wishes to confess. Nobody can force him, nobody can compel him. So if a man himself comes forth and he says that he wishes to confess, the judge will give him a word of caution, will tell him that he will be punished nevertheless, and that he is not under a mandate to confess. Law allows him to keep his mouth shut. He will still be given the right to defend. All his rights will be told to him. Everything will be narrated to him. The entire process will be explained to him by the judge himself, and the confession will be recorded off camera. Right? So this is it is a very complex procedure, but out of 100, it's just 1 or 2 who confesses. Everyone else is just, they declare themselves not guilty. Because if they say after a certain, after the evidences and everything are done, the judge actually asks the person, do you plead guilty? So the person is asked if he wishes to confess, and if he says not guilty, that means the trial will go on. Now he will be given the right to defend himself. But if he says that yes, I'm guilty, then the process will be different. The confession will be recorded and the person will be convicted. Is confession made through video, audio in court is valid? Yes, it is. Yes, it is. There hasn't been a Supreme Court authority on it, but it has been it has been noted time and again that in certain circumstances, courts have allowed audio video conferencing for various things, including recording of testimony. Bilkis Bano versus State of Gujarat is something that I am going to discuss as part of your Hindu editorial analysis. I think it is important because it is important that you know what heinous thing has been done by the Gujarat state. You ought to know about the Bilkis Bano judgment, the Bilkis Bano facts, who were convicted, why were they convicted, why have been they released. You need to know everything, and I shall explain this to you either tomorrow or day after. So we will be discussing Bilkis Bano judgment as part of our Hindu editorial analysis, because it was there on 17th, I guess. Yes, so don't worry, I'll tell you all about it. Don't worry. Now, since I have explained everything to you, you can just read. The scope of interference in an appeal against acquittal is very limited unless it is found that the view taken by the court is impossible or perverse. It is not permissible to interfere with the finding of the acquittal. Now, this is really not important, as we have already figured out. Okay. Right. Is there any problem whatsoever? Did you understand? Is surrender similar to judicial confession? Alfia, kind of. Yes. Surrender is similar to judicial confession. Basically, surrendering is an act. So, surrendering is an act wherein you surrender yourself before the investigating agencies. Okay, you surrender yourself before the investigating agencies if they are looking for you. So, you surrender to them, they will take you into custody, the trial will commence, you will be taken to the judge, and there you can confess. Also, one very important thing again related to this only, the relevance of confession before a police officer. I'm sure people know about it. Any confession made to a police officer is absolutely irrelevant. Absolutely irrelevant. If you confess to your friend, it might be taken into account if it is corroborated by other facts, like the one I told you. But if a person confesses before a police officer, the court completely dismisses that testimony. That statement amounts to nothing whatsoever. It cannot even be corroborated, because judicial system does not trust the police enough to accept what is said to them, because history testifies, or there are various evidences and there are various proofs that show police brutality, and if they are actually allowed, if confession made to them is declared to be relevant, they would do anything in their power to extort the confession. They might as well cut his fingers if he is a tough man, if he is a tough bird, to extort the guilt out of him, to extort the confession out of him. And the judiciary and the laws, the parliament, the lawmakers, everybody was aware of it, that if we give them a power, or if we confer them with the power to accept statements in the form of confessions, they would do anything. They would torture a person to an infinite extent to extract the confession. And that is why anything said to the police, anything said before the police is absolutely irrelevant, especially done in a police custody. Okay. We are not talking about investigation. Okay, we are not talking about investigation. The only job of the police is, or the investigating officer is, to declare what evidences he thinks would be relevant in the given case. So it is his job to put forth the people who are willing to testify, the number and the names of witnesses. Now, whether or not their testimony is important or is admissible will be decided by the court later on in the trial. Okay, so the figuring out of the case, or the making of the story, is actually done by the police, but what would be the result of that story completely depends on the police. So it is kind of like, a writer has written a screenplay. Now, how will that screenplay be directed completely depends on the director. So director is the judge, writer is the police. Very appropriate example. Now, another question is anything said to the police relevant? Anything? Yes. Section 27, Evidence Act. Now, I am giving you very, very important laws here. They are important. Okay, they can be asked in the exam. That is why we are discussing them. So, please pay attention. Section 27, Evidence Act, which calls for discovery. Okay, what is discovery? Now, if a man says that I committed murder, or let's say that we have A, and he admits before a police officer that he has committed murder of B using a knife. Using a knife, right? Looks like a kulfi, but whatever. And this knife he has hidden in his house. Okay, this is his house. This is the only house I can draw. Now, this is what A says to B, that I murdered B using a knife, and I have hidden that knife in my house, and I have buried it inside my child's room, and I have covered it with carpet, etc. Now, Section 27 says that the fact, there are two statements. What? Murder. I murdered. And the second fact is weapon. According to 27, this is relevant. This is irrelevant. So, if a statement by an accused or a suspect to the police officer leads to a discovery of an additional fact which is relevant to the case, that discovery will be relevant. But whatever is said surrounding that discovery is irrelevant, which means that the fact that A said that I committed murder is irrelevant, but his statement that I used a murder weapon and I hid it inside my house in my child's room, that statement will be relevant. And not just the statement, only the fact that the police is able to discover the murder weapon. So that discovery is not inadmissible because it has been made by the police and the person has admitted to the knowledge of murder weapon. That is not irrelevant. The police have found the murder weapon. They will continue with the investigation based on the fact that, who used it, what are the fingerprints, etc. They'll figure out who the murderer is. But the statement that has led to the discovery will be relevant. So any statement that leads to discovering an additional fact, which might be anything relevant to the case, can be held as an admissible evidence under Section 27. Only discovery of an additional relevant fact. Okay, I hope you are clear. That is what the relevance, or that is what the scope of statements made to the police officers is. Moving on. We are done? Yes, we are done. So that is it. You don't need to know anything apart from this except 136. No, that's okay. Now we have another very important section, which is section 313 of CRPC and Jaiprakash Tiwari versus State of Madhya Pradesh, where the Supreme Court said that non-fulfillment of section 313 CPC may cause grave prejudice to accused, solemn duty of the court to consider defense. Now, what does it mean? There are two kinds of judicial systems. One is adversarial. Okay, now your homework is to find out what adversarial is. Another one is inquisitorial. This one I'll explain. Inquisitorial. Okay, our judicial system is inquisitorial, not adversarial. So, according to our criminal process, our judges do not sit like a mute umpire. They participate very, very actively in a trial, which means that they get to question everything and everyone, including the evidence and the investigating agencies. They can question the prosecution and the defense. If they want a certain evidence from any of the parties, they can order it. They can do anything that they want to figure out what exactly happened and to figure out if the person is guilty or not. right? So to meet the ends of justice or to impart complete justice, they are given a full freedom to do anything that the complete justice requires them to do. Now this is what inquisitorial is. So our judges are not mute umpires, they are active participants in every case. Now what does section 313 says? It is basically facilitating the system. According to section 313 CRPC, a judge can talk to the accused alone, right? So talking to the accused, basically there are two parties, right? A versus B. Now A has alleged something on B, or A has accused or made accusations against B. Now B will also have a certain story. He might have a defense, he might have a certain story, he will have a certain side. Okay. Now, according to section 313, the judge will listen to the defense's story. Okay, this is actually a shall clause. Shall. It is a duty of the judge to talk to the accused, to listen to his side of the story, to give him a reasonable opportunity to explain himself. And it is not just the evidences that are presented before the court. He is given the opportunity to articulate the evidences, to explain the evidences, to present whatever it is that he wishes to present before the judge. He will be given complete opportunity by the court. That is what section 313 stipulates. Very important. Now, the Supreme Court recently reiterated in view of section 313, it is the duty of the courts to consider the defense presented by an accused and to give reasons in writing while adjudicating on the same. So, if they are giving a judgment or an order or adjudication on the defense or the evidence presented by the defense, they are under a duty to give it as a speaking order. They have to tell or rationalize everything. They have to reason everything. Why have they adjudicated what they have? Okay. The court explained that section 313 envisions a reasonable opportunity to be given to the accused where all adverse evidence is presented in form of questions for them to articulate their defense. Okay. Now, non-fulfillment of the true spirit of 313 may ultimately cause grave prejudice to the accused. That is why it is something that cannot be just done away with. The court may not have, an opportunity or a benefit of all the facts that are important. The prosecution may miss out on something which can be clarified through the defense. And that is why, to get the complete picture of what exactly happened, it is the duty of the courts to listen to the defense also. Got it? Now, this conviction were basically based on attempt to murder. I hope 313 is clear. Right? I'm assuming it is clear. Now, what exactly is attempt to murder? Another thing which is very important. Attempt to murder is given under section 307 of IPC. Now, attempt to murder is actually an inchoate offense. Okay, inchoate offense. Let's say that A found B is cheating on him and B is his wife. Okay, let's say that A found that B, his wife, is cheating on him with C, who is A's best friend. Now A is outraged, he's heartbroken, he's hurt, he's filled with hatred. That's a disgusting act like this can be committed by his best friend and his wife. So he decides to murder both of them, a passionate crime or a crime of passion, and he invites them or he takes them for dinner, or let's say he cooks for them. Now he makes their favorite dishes, and the favorite dish is common, it is soup. And let's say that he mixes poison in the food. If B and C eat the food, it is very, very likely that they will die. So as soon as they consume the food, A's mission is completed. he has done his job. What he wanted to do, his intention is complete. He has executed his intention. So as soon as the person executes the intention, everything falls on the destiny. Now, will that execution be successful or not is actually not in his hands, right? So if the execution is successful, meaning thereby that what he intended to do is actually happening, then his mission is accomplished and we call it a full-fledged offense. But if for any reason whatsoever he is very unlucky, not just he got cheated, but the destiny also wants to make a fool out of him, and they do not eat the food, the dog jumps on the table and the entire food falls on the floor. So they don't eat anything, they are saved. Now this is where an interfering element is present. So if during the execution of a crime, if a person has done everything in his power, like he has committed or he has completed his action. For example, a person shot the bullet to, a person fired a gun to shoot a person. Now, as soon as the bullet leaves the gun, it is out of the shooter's powers. Whether or not it will hit the person is completely, unforeseeable. Depends how good that person can shoot. So, as soon as the bullet leaves the gun, there is nothing A can do. Similarly, as soon as B and C eat the food, there is nothing A can do. Now, everything is based on will the mission be accomplished. If the mission gets accomplished, we call it a full-fledged crime. But if something interferes and the crime remains incomplete, it didn't happen because something interfered with it, then we call it an attempt. And mind you, attempt is also punishable. Attempt of all the crimes is punishable. So if a person is a pickpocket, let's say A is a pickpocket, he puts his hand inside a person's pocket and finds the pocket empty, he has still committed the crime. He has committed attempt to theft. Why? Because it is only by luck that the pocket was empty. If the pocket would have been full, if there had been a wallet, A would definitely had stolen the wallet, right? So there is an interfering element that has interfered with the fact or with the execution. Nevertheless, the intention is there, the act is there. The only fact is that the res is not there. The result did not come out as expected. But since intention, actus, everything is present, causation is also present, we still deem it to be a crime, which is a crime of attempting, and the person is still punished. The punishment is not as severe as the crime itself, but the punishment is there. Okay. Clear everyone? Any doubt whatsoever? Sounds like Rustam movie, yeah, but Rustam was not that person's friend, right? Anybody, any doubt? I hope it is clear. Right, so these are the illustrations. Let's say A shoots at Z with the intention to kill him. Now, under such circumstance, if death ensued, A would be guilty of murder and A would be punished. But if the death is somehow, interfere with, the death does not happen for any reason, he will still be liable for attempt to murder. Right. So that's it for all, guys. Thank you so much. I hope you enjoyed and understood everything. We shall be discussing Bilkis Bano either day after tomorrow or tomorrow. The notification will be given to you. Bilkis Bano judgment is important. It actually exposes the grey area of legislation and the government, something that you need to know about. And also, students who are facing problems in their mocks and students whose score is stuck, not able to score better, not able to score higher, the score is coming down, etc. All those insecurities, problems. I'm actually coming out with a session to clarify the problems, to solve all your problems at 5 p.m. today. Okay. The session is at 5 p.m. today, so make sure that you attend it. Later on, when you face the problem of not being able to do as well in the mocks, don't ask me. Because when I take the session, you don't attend. Right? So, since I'm taking it, it is your duty to watch it and to figure out what your problem is. So we'll deal with that problem at 5 p.m. Be there. And everybody needs to like the session. Okay, comment on it. I would really like it if you can share it, and please subscribe to our channel if you haven't already. I shall see you at 5 p.m. again on the same channel on YouTube. Take care, guys. Thank you so much. Bye-bye. If the person confesses his crime, it is true that no, it is not true. It is not necessary. It is a possibility, but it depends on the judge. Okay. Thank you so much, guys. Thank you.